Hello, my name is Perrin, and this is my presentation on an answer to a complaint on pleading paper. To review where we are in the litigation process, I am referencing the Elia Law Firm litigation timeline we've used in class a couple times. The process began with the plaintiff submitting a complaint and serving the defendant. We're right here where this red flag is, and the defendant is filing either an answer, a demur, or a cross complaint in response to the plaintiff's complaint. An answer is a document that responds to the plaintiff's complaint and offers some denial, as well as introduces any new facts the defendant wants the court to consider on their behalf. Just like a complaint, an answer is a pleading. The use of these documents helps both sides assert their claims and help the discovery process by determining the disputed facts. The format of an answer on pleading paper is subject to the California Rules of Court section 2.100 to 2.119, which we'll talk about later in the presentation. After a complaint is served to the defendant has 30 days to respond with an answer, according to the California Code of Civil Procedure, Section 412.20. This 30 days starts after the date of service. If a defendant does not respond within 30 days, the plaintiff can file a request to enter default and move for default judgment. This is when the judge reviews the plaintiff's complaint and can award an amount up to what the plaintiff has requested as relief in their complaint. This demonstrates the impact of filing a complaint accurately and making sure what the plaintiff wants out of legal action is included. If the case goes into default, the judge can only rule on what is in the complaint. Additionally, this emphasizes the importance of responding to a complaint within the proper timeline. If you fail to do so, you will lose your ability to argue your case and are subject to whatever judgment the judge awards to the plaintiff. California Code of Civil Procedure, Section 431.30, describes the necessary elements of an answer. The first is a general or specific denial of the material allegations of the complaint controverted by the defendant. The second is a statement of any new matter constituting a defense, also known as an affirmative defense. We will look at each of these requirements individually. Additionally, Section 431.30 Part C also stipulates that affirmative relief may not be claimed in the defendant's answer. Affirmative relief is what the plaintiff is entitled to from the defendant, and for the defendant to claim the same relief, they would need to file a cross-complaint. However, an answer may contain a prayer for relief. Here, the defendant can ask for the plaintiff not to be awarded any damages or for the cost of suit and attorney's fees. A general denial is a statement that generally denies all the allegations made in the plaintiff's complaint, instead of individually admitting or denying each allegation. This can be a good method to conceal the strategy of the case from opposing counsel. However, you can only write a general denial if the complaint is not verified or if it is a limited civil case, meaning under $35,000. Verification simply refers to whether a plaintiff has signed a declaration that their complaint is true under penalty of perjury. A form for general denial is available on the courts.ca.gov website and has instructions for rules on its use. It must be used if the amount involved in the case is less than $1,000. It may be used if the complaint is unverified, or if the complaint is verified but it is a limited civil case, less than $35,000. A specific denial is just like it sounds, a response to each specific allegation. The defendant has more options in a specific denial and must be very careful to answer all the allegations in the complaint. California Code of Civil Procedure, Section 431.30F, explains that the defendant can specifically state which accusations their denials refer to, admit to only specifically stated allegations, and generally deny all other accusations, or they can deny some accusations by lack of information and deny or admit all others. For example, in a dispute over a breach of contract, a defendant may deny the existence of the contract entirely, they may admit the contract exists but deny that they breached it, or they may claim they don't have enough knowledge about the contract to admit or deny its existence. The key element of a specific denial is to ensure you respond to every allegation. It's not enough to only respond to some and leave some unanswered. Any complaint not answered to is considered admitted to. Just like a general denial, a specific denial can also be done using a form. In this example, I'm using the answer for a contract complaint, Form PLD C010. The form contains all the necessary elements of a denial. The first is the denial of the allegation, and we can see the characteristics of a specific denial in accordance with California Code of Civil Procedure 431.30F from the previous slide. The first is either a denial of all the allegations, admitting to all the allegations except the following, or stating that the defendant has no knowledge of the allegations. The second required element of an answer is a statement of any new matter constituting a defense, or an affirmative defense. An affirmative defense is information offered by the defendant that introduces new facts to be considered on their behalf. If it can be proven true, it can result in the denial of damages to the plaintiff by providing an excuse for what the plaintiff claims happened. For example, in a breach of contract, the defendant may admit the contract exists and admit that they breached it, but if they can present a valid reason for the breach and why the contract should be unenforceable, they could prevent the plaintiff from getting damages. Of note, a defendant is restricted to using only the affirmative defenses included in their answer at trial. All other affirmative defenses not listed in the answer are considered waived. So it's important to list all the affirmative defenses you consider even remotely useful in the case if you want the option to use them at trial. The following slides are screenshots of my document. The first picture is of the first page of the answer. It's formatted as covered in California Rules of Court section 2.111 and specifies size of margins, where the contact information goes, where you leave room for the clerk, what line the title goes on, where the name of the case should be, etc. It's nearly identical to the complaint's caption, but instead it contains the defense attorney's information. If you're going to write an answer on pleading paper, you should definitely use a template, but make sure it meets all these requirements. Next, the first requirement that an answer must have is the denial. In this case, the defendants, Emerald's Catering, are generally denying each and every allegation of the breach of contract and fraud asserted by Benjamin and Sarah Sampson in the complaint. By using a general denial, they are ensuring that every complaint is responded to and are not accidentally admitting to any accusation. This can be accomplished by a specific denial as well, and may be more appropriate if some of the facts purported by the plaintiff are true. This next screenshot displays the second requirement for an answer. A defense submitted an answer to the accusations. These are just a few affirmative defenses I selected for this answer. The format of these defenses can be found in California Rules of Court section 2.112. Each defense must be numbered, and the answer must state the nature of the defense. Additionally, make clear who is asserting it, the defendant, and who it is directed to, the plaintiff. In our example, this seems straightforward, but in a case with multiple parties on each side, it would be important to be as specific as possible as to which party each defense is aimed at. As I stated earlier, it is better to include any affirmative defense even if you aren't sure it's entirely useful. Otherwise, you're waiving your right to use it at trial. The last section of an answer is not required but encouraged and includes a prayer for relief. This is different from affirmative relief, which would require the defendant to submit a cross-complaint. Typical prayers for relief include no judgment being awarded to the plaintiff, dismissal of the complaint, judgment in favor of the defendants, and for the cost of suit and reasonable attorney's fees. Thanks for watching. I hope you have a better understanding of what an answer is and its major components. I made the slides from a template from Slidesmania, and I used images from Unsplash.